All right, now we're joined by Steve Gonzalez, who's running for re-election to the Supreme Court, position 8. So go ahead with a 2-minute introduction.
Thank you. My name is Steve Gonzalez. I'm running for position 8 on the Supreme Court. I'm just completing my first full term, so I've been on the court just over 6 years. I was a trial judge for 10 years before joining the Supreme Court, and an assistant U.S. attorney before that, and a city prosecutor for Seattle before that, and before that in private practice. So I have a mix of private and government work at the municipal, federal, and county level, and now for the Supreme Court. I used to chair the Access to Justice Board, a statewide board that works to improve access for everyone regardless of the barriers they may face due to income level or language ability and other factors. Now I chair the Interpreter Commission, making sure that we have interpreters statewide and the judges and lawyers are trained to use them properly, and that there's ongoing education for the interpreters themselves, and a discipline process in case they break the rules or are accused of doing that. I've been rated exceptionally well qualified by 10 different bar associations this year for re-election. I've received a number of awards throughout my career, including Judge of the Year and Vanguard Award from Washington Women Lawyers, the King County chapter. I'm involved in mentoring lawyers from diverse backgrounds. I am on the board for Washington Leadership Institute, which trains diverse lawyers to take leadership roles in the bar statewide and beyond. I co-chair our traveling court, and we just got back from Nispelem, where we heard cases on the Colville Confederated Sovereign Land, and it's a privilege to serve, and I look forward to your questions.
Great, thank you. So now we have our 4 prepared questions, and they are right in front of you if you want to turn them over and read along with us as we read them aloud. These are 2-minute answers. And Elizabeth, will you do number 1 for Supreme Court?
What do you think were the top accomplishments of the recently completed term of the court?
We have 3 terms a year. The term we just completed ended in March, and then we, in April, have a variety of other things going on. We just started up our new term. One thing that we accomplished is that we are getting our opinions out faster than we used to. I've been now for 1 year and 4 months the new circulation chair, and that's the person who's in charge of keeping everyone on track, which makes me less popular with my colleagues, because when I'm visiting, sometimes it's to tell them that they're behind and to urge them to get their work in circulation. But I think it's an important role. I think the timeliness of our opinions is critical to their effectiveness. We have been not meeting the time frames that we have set for ourselves, and so we've improved by about 40% since I've been circulation chair. I don't take all the credit for that. I think we have a new sense of urgency in getting our opinions done. I think Justice Yu has been a help with that. Both of us coming as trial court judges understand how important it is to the litigants to get the answer back and to have it be clear and understandable so that it can be applied. We've passed a new rule on jury selection, which is intended to reduce racial bias in elimination of jurors. It's been a project we've been working on for a long time, going way back to an opinion that I wrote a concurrence in the St. Cali case. And we've just issued a model language access plan that we're urging every court to adopt to make sure that people have access to court regardless of their ability to hear or their ability to speak or understand English.
Great. Nicole, number 2.
Please share an incident or aspect of your work history that has changed or enhanced your interpretation of the law.
When I was an assistant U.S. attorney, I did some immigration enforcement work. Before that, I was a domestic violence prosecutor, and I did elder and child abuse cases. And from that work, we had the policy in the office that we not inform anyone or give anyone's information to ICE for enforcement, because we thought it was important that victims feel comfortable calling for help and not being worried that they or a loved one will get deported because of that notice. I then learned much more about how the immigration enforcement system works as an assistant U.S. attorney. And when I joined the King County Court as a Superior Court judge, together with Judge Yu and then Judge Yu, now Justice Yu, and now retired Judge Fleck, we proposed that the King County Court adopt a policy not to allow ICE to to enforce ICE warrants at the courthouse so that people would feel free to come to court and to have their matters heard on the merits without fear that there would be immigration enforcement. We passed that policy. We got ICE to agree to it. I specifically met with them and they agreed to respect our policy. That work and that connection and the importance and the agreement of law enforcement that was the best policy led me to take those steps. Now on the Supreme Court, we've sent a letter that our chief authored asking ICE to respect that policy statewide, and we'll see how that works.
David, number 3.
Please describe your beliefs around the concept of restorative justice and whether you see a potential for judicial action from the bench as influential on that process.
More directly, trial courts can have an effect on restorative justice, as that's mostly where the change can happen. In the cases themselves, it's harder to do it from the appellate, especially the Supreme Court level, but what we can do is convene the discussion. And what I did before I became a Supreme Court Justice was co-founded the Race in the Criminal Justice System Task Force together with professors at the 3 law schools and leaders in the minority bar associations, prosecutors, defenders, elected officials, etc., to study the problem of disproportionality and come up with recommendations on how to reduce it. I think that's a major step in making the system itself more fair, and that people will have more faith in it if they believe that it's a more fair system. And we've continued that work through the Minority and Justice Commission, through the Gender and Justice Commission, and other efforts by the court.
Great. And number 4.
If elected, do you have any specific priorities for the court's next term?
So if I get elected, that will be determined in November, and the next term would be starting in next January, and I don't have anything in mind except I hope to continue as the chair of the Interpreter Commission and the Circulation Chair, and to bring the court through the Traveling Court Committee, which I co-chair with Justice Owens, throughout the state, to give people the chance to watch oral argument and to interact with the students that we invite to hear those cases. I think that the job that we have as a justice on the Supreme Court is a very important one in our democracy, and I take it very seriously. But my promise to everyone is that they're at no advantage whatsoever before me, but also at no disadvantage, and that I'll do my best not to decide the case based on what I'd like the answer to be, but what I think is required. So I hope to continue being the best justice I can be, and that means improving every year if I get to stay.
Great, thank you. So now we'll open up to follow-up questions. These are 1-minute answers. People can ask whatever.
I'm sorry, I couldn't read.
Sorry, these are 1-minute answers. And we will start with Ben and then Nicole.
Seattle prosecutors are seeking to vacate more than 540 convictions against people caught carrying small amounts of pot in the city before legalization. Do you think, considering the racial inequities and how possession charges were distributed previously, this should be expanded throughout the state?
It wouldn't bother me at all if it is. I think that's within the discretion of the prosecutor. One of the things we pointed out in our Race in the Justice System Task Force was the disproportionate enforcement of drug laws. That was one of the things we recommended change, and I think that's a good step.
Thanks.
Nicole?
Can you describe your most difficult case and why you thought it was harder than others?
Well, there have been difficult cases both at the Supreme Court and then during my 10 years as a trial judge. I think now the ones that are hardest for me are in 2 categories. The death penalty cases, because of the facts themselves and the weightiness of the decisions that we make. And the cases that involve termination of parental rights, because in those cases we're being asked not just to make a decision about what's happened in the past, but to predict what's in the best interest of the child in the future. And we're dealing with cases in which we don't always have complete or the best information, and those are very difficult decisions to make.
Additional questions? Jason?
I'm going through some expungement processes back in Alabama, and like judgment or, what, my question is, what's the big difference between, sealing, and vacating?
Well, when it's sealed, people can't get it, but it's still there, and it's vacated, it legally no longer exists.
Thank you.
David?
I believe so far in this process, you're the 11th judicial candidate at various levels that we've interviewed. But I also believe you're the first one that actually has an opponent, at least at this point in time. Filing's not complete. Do you feel you were targeted? This is turned into an awkward question. I apologize. Do you feel you were targeted, and do you feel that you have an effective campaign game plan?
I've been working hard as a justice. I spend a lot of time on every case that comes before the court. I also spend a lot of time in the community, even when it's not a campaign year. I've always been that way. I care a great deal about civics. I speak at middle schools, high schools, colleges, law schools, civic events, Rotary clubs, wherever people are interested in democracy and the court's role in it. The court has come under some criticism by some for some of its rulings. I'm not ashamed of any of the cases I've written. I think the court always should consider how it can improve. I think timeliness is one of the key factors. I know that there was, in the last cycle, great disquiet about the charter school decision, and that led to some people getting opponents. This year, I'm the one who got an opponent. I would let him speak for himself on his reasons for running against me. I decline to answer that further.
All right, got time for a few more questions. Jason?
Where do you see our justice system in 20 years heading?
One of the key issues is how the court will remain relevant when many cases, at least for those with means, are being decided through private arbitration and mediation, which means we lose a body of common law that is the way law has changed and developed in the published cases that come from the court, obviously because those private adjudications don't result in a written decision and the outcome is not precedential in any way. And so that's changing, and I think we need to make sure that we remain relevant. There are lots of things that would help. One, I think, would be giving a more secure time to trial timeline for litigants so that they know when their case is going to be heard. And budgetary problems and other delays have hurt in that regard, especially for civil cases that are often secondary and bumped because of criminal cases. I also think we need to use technology better, and when you're sending a summons to somebody at an address using mail, that's not the most effective way of communicating any longer. Apologize for that.
That's all right. Cole, did you have another one?
Sure. Who are your judicial role models and why?
I've got a couple of judicial role models. One was Judge Barbara Rothstein, who I tried cases in front of in federal court, and I always appreciated how well prepared she was and her demeanor and the respect that she showed to everyone in the court. Justice Charles Z. Smith, who passed away recently, was a mentor of mine and he encouraged me to consider a judicial career 25 years ago. So he's someone that I look up to.
We have time for a few more questions. If anybody has them.
So, I'm very interested in privacy, starting with medical records and then with voter privacy. And I'm curious what the impact of the EU's moving forward on the new privacy legislation, what kind of impact to anticipate here in Washington State, the opt-out and the right to be forgotten.
It's a very interesting issue you raised. The U.S. Constitution doesn't recognize privacy explicitly. It's been found by the Supreme Court in case law. You might be aware of that case. The state constitution, though, does explicitly provide the right to be protected in your private affairs. So this state has recognized that interest. We have competing interests. We have open courts requirements, and we have the Public Records Act. And so you can be a zealous advocate of one, but that means trampling on the rights in the other regard. I think this is an important debate that probably shouldn't be decided by the court in most instances. It needs to be when someone's individual right is being violated by a statute or executive action. But otherwise, the broader policy question and the balance between those two, I hope, is expressed through legislation by people who thought about this and made the policy decisions.
Additional questions?
I have one.
Sure, Jason.
Jury selection. I know we provide physical accommodations for somebody who has physical needs. Do people with mental disability get the same type of accommodations on a jury, and can they serve?
Well, the requirements for serving on a jury are fairly basic, and if you can meet them with or without accommodations, you have a right to serve, and that right would be protected under the ADA and probably the Washington law against discrimination. So it would just be a question of, can the person serve and what accommodation do they need? I don't remember a case of that ever coming up before me. It's an interesting question, but I don't see any prohibition against someone serving.
Thank you.
Good. Time for a couple more.
How do you handle conflict of interests on the bench?
There are rules that govern conflict of interest. I mean, it's a broad term, but I'm taking that as any time you can't hear a case. And I have recused in a number of cases, some because I knew the person involved, some because I had been the trial judge on the case before, and so I thought I was right. My mind was pretty much made up, so I didn't think I could be fair in that case. But the rules that govern it, and when there's a question, I consult with colleagues or the ethics line, and that's how I approach it.
Okay. Additional questions? I get emails every time the Supreme Court issues decisions, and I always just skim each one. And I don't know if I've noticed a trend, but has there been a trend away from unanimous decisions recently? I remember one just a few months ago where there was no majority opinion. There was a majority result, but it was 4 or 5 or 6 different concurring and dissenting opinions. I don't know if this is necessarily a problem, but is there a trend away from consensus on the court?
No.
Then it's aberration.
We have a long, rich tradition of splintered opinions. I think that most of our opinions, even now, are still unanimous or with a substantial majority. But there are those times when people have strong feelings, and it results in more than 2 opinions in a case. And maybe there are 2 or 3 more this year than last, but there have been ebbs and flows in that throughout the existence of the court.
Okay, thank you. Additional questions? Time for maybe one more?
I'm sure you have.
Oh, no, I dig deep when nobody says anything. Nicole, did you have one?
I give you a minute to talk a little bit about your background before law school. What did you go to undergrad for and all that kind of stuff?
Sure.
A little about you.
Well, I'm the first one in my family to go to college, and I went to college initially with a utilitarian idea in mind that I wanted to be able to get a better job than I could without that education. And when I got there, I loved it so much. I majored in East Asian studies. I got to live in Japan as a sophomore and in China for half of my senior year. And then I liked it so much I went back on a scholarship to Japan for 2 years before I went to law school. Then I went to law school at UC Berkeley and then began practicing, and practiced in private practice, doing international business law mostly, but it was my pro bono work, my volunteer work, that got me into court, mostly doing immigration cases and helping people with protection orders when they were victimized by their significant others. And so I left the private practice and became a municipal prosecutor and did domestic violence work. So that's sort of the progression, at least through the career.
All right, so now we're about out of time. If you want to take 30 seconds for a closing statement.
Well, this used to be my district. We live in Olympia now. The family has moved down there. My commute is much better, but I do miss the 36th. I thank you very much for taking the time to have me here. I would appreciate your endorsement if you're willing to give it. And it's been a pleasure speaking.
Thank you.
Great, thank you very much.